Hello, hello. Is anybody here? Testing, testing. Is anybody to class? Anybody reject?
Good evening, everybody.
Good evening.
Good evening.
Okay, we're going to get started in a second or two. Okay, tonight is our final session together. And we'll be looking at Module 11, Legal and Credit Risk for Property Mortgage Transactions. Quite a bit of this information, particularly in the beginning, we have we've encountered in early modules. This is Module 6. Get through it rather expeditiously tonight. Okay. So Module 11, let's start the relationships and their clients. Can everyone see the screen, the PowerPoint presentation?
Yes, sir.
Okay, great. Okay. So this is a brief outline of it. Relationships between financial institution, professional, preservation of the duty of confidentiality, and data protection, mainly focusing on the Data Protection Act, important aspects of legal liability, and there are 3 subsections, and then we end with credit risk. So that's the the relationship of financial institutions and the clients are characterized by 3 important legal components. The first of which is on the screen there, contractual, and that is governed by common law of contract. Although there's some important statutes that may also govern this. A little bit more. Okay, so and you can follow along in your manual. We're on Module 11. Contractual is based on a single primary contract. Contract may have expressed and or implied terms, and there may also be other separate contracts related to and inclusive of other banking financial services. So, for example, you may have a client who has opened up a deposit account, that has a savings account or checking account, and they also have other accounts with yourselves. They may have credit card, or they may have lending facilities, a loan with you, or they may have a business account with you, and they're one of the signatories on that account. Is also characterized by certain duties and obligations which are owed to the bank. Owed by the bank to the customer, such as the duty to honor checks where credit balance authorized overdraft exists. And then there are certain duties and obligations owed by the customer to the bank, such as the duty to take reasonable care in drawing checks on a checking account or current account. Also, these duties and obligations may be expressed as implied, as stated before. They may be statutory or customary, and there may be certain liabilities that derive from a breach of such duties and obligations that are contractual as well. Additionally, there are certain rights, indemnities, protections, and legal safeguards inherent in bank customer relationships. And these are primarily a duty of due skill, care, and attention by a reasonable agents are held to a higher standard of care, and also a duty to act as a fiduciary. I'm going to talk about that we can talk about that right now. A fiduciary aspect. Normal customer relationships, particularly with banks, there's a fiduciary relationship which may not automatically arise, except where generally or specifically the financial institution expressly undertakes to contractually and or legally fulfill a fiduciary role, for example, providing financial advice. There's a case in point here, the Bristol case 1996. Okay, the Bristol case of 1996. A fiduciary is defined as someone who has undertaken to act for and on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. We can come across those two of those three words again. The distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to have a single-minded loyalty of his fiduciary, and the principal in this case being yourselves, a financial institution. So there are four things that a fiduciary should do. First of all, is they should act in good faith. They should not make a profit out of his or her trust. Thirdly, they should not place him or herself in a position where his duty and interest may conflict. And fourthly, they may not act for their own benefit or for the benefit of a third person without the informed consent of his principal. And the principal being your client. Okay. A corollary of the general principle of fiduciary responsibility is the fact that not every breach not every breach by a fiduciary is a breach of fiduciary duty. The breach of fiduciary duty implies disloyalty or infidelity to the client, and although it need not be dishonest, it must be intentional. Okay, so there's where you can act and you can say something intentionally saying it without knowing it to be dishonest. But the fact that it is said, there's an intention. Okay. So for example, and I'll come back to this later, you may have a case where a husband and wife may have come to you, say to get a mortgage, and the property may be in the wife's name solely. Okay, and you may now advise them to put it in joint names in order to get the mortgage. Okay, so the mortgage could be in joint names. It is not necessary for the property to be conveyed by the wife to her and her husband in order for that to happen. There are other means by which this can be done. So the husband could join in as guarantor. He can join as mortgagor, but without um, uh, the rights of the property, any equity being transferred to him. There was a case that I'm aware of where this happened, and it came back to bite the financial institution. Okay, and so while that information, um, I mean, it can be done. It can be done. Okay, so it was not necessarily dishonest, but it was an intentional act on the person's on the person's part who gave the information. So we need to be careful in the execution of our duties and giving advice to our clients, particularly lending clients. Also, duty to exercise reasonable care is not specifically a fiduciary duty. An agent is bound to exercise reasonable care, skill, but failure in this respect does not constitute a breach of fiduciary duty. Mere incompetence is not enough. There's a noteworthy article explaining the above on the previous slide, and I have a link down at the bottom of the screen. It's interesting to note that in the National Westminster Bank versus Morgan 1985 decision, that the banker-customer relationship was held not to be a normally fiduciary one. A fiduciary relationship is only presumed that legally develops if the bank expressly or in some instances impliedly acts in a manner that may attract the presumption that it has, by its intention, by its actions actually, assume a fiduciary role in relation to its customers. Okay. And again, I want to reference the example that I gave about the husband and wife, where one party owned the property outright, and they were advised to put it in joint names. You're not a legal expert, and so any advice like that really ought to have been coming from an attorney. But if you hold yourself out to give that type of advice, again, you must be careful, because it says down here, providing investment advice or lending advice outside the scope of your duties to the customer and standard products and services. I may have mentioned it in one of the previous classes that at one time when Fidelity had two arms of its bank, it had the commercial bank and it had the investment bank. They actually worked together, and so a person who was in lending, would offer the client to have a financial advice session. But that advice session was not with them. They would have to set it up with someone on the investment bank side. Okay, I think it evolved over time where the staff had been sufficiently trained, and management and the executive team was fairly satisfied that certain investment advice or advice other than on the lending side, that the officers were allowed to, or certain officers were allowed to also advise clients on a investment / wealth management, albeit an introductory level basis. Okay. I don't know what that position is now because they're two separate entities, and what the relationship is, but that is one example that I know of where the bank had its staff involved in lending, but also contracting with another arm of the group to give that fiduciary advice. Okay, it probably happens in some of the other financial institutions as well, because, for example, Scotiabank also has a wealth management side. So I presume that a similar thing happens with them. Anything that on an investment nature, they would refer to their professionals on the wealth management team. Okay. So let's move to professional. Okay. Conflict of interest obligation and the contractual fiduciary duty not to disclose or use confidential information belonging to a client may both occur in the context of the duty of confidentiality, which must be observed, upheld, and protected by all financial institutions in the Bahamas. The duty is generally of the banker-customer contract, although it may be expressed in the bank's terms and conditions in its formal customer opening documentation and other agreement. The duty of confidentiality, as it relates to Section 19(1) of the Banks and Trust Companies Regulation Act 2000, and common law principles outlined in numerous English and Bahamian cases involving the duty of confidentiality in banking and other financial related matters, have provided the legal framework from within which the concept of bank secrecy in the Bahamas has been observed, practiced, and I don't really know if that really stands anymore as ultimately preserved, but at least to some extent now preserved. Okay. The duty of confidentiality. Generally, the duty of confidentiality is a fiduciary one, which a banker owes to the customer and upon which he can be sued for breach of contract, for unlawful or unauthorized disclosure of information to a third party, inclusive of spouses, relatives, financial institutions, and other unauthorized parties. This not only applies to a customer's account information, but it also extends to information relating to a customer's identity, assets, liabilities, and financial affairs generally. When we get to the Data Protection Act, we will see how this also plays, and it goes a little more in depth, talking about unauthorized disclosure of information and the extent to which the information relates. So unless the bank's disclosure of a client's banking or financial information falls within one of the four exceptions to the duty of confidentiality expounded in the English Tornier case, 1924, notably the duty to disclose client information to a third party, the bank will be in breach of the duty of confidentiality and ultimately the implied terms of the banker-customer contract. And what are those four exceptions based on the Tornier case? Well, here they are. The four exceptions are under compulsion of law, in the public's interest, in the bank's interest, or within the express or implied consent of the customer. And for those of you looking for an article that might help to explain the attorney case, again, there's a website at the bottom of the page. Okay.
Can I ask a question now?
Sure, go ahead.
We know that in the common law or British Commonwealth or whatever, is this based on international law, period? Or was only within a certain umbrella of financial jurisdiction of some sort?
Okay. Well, the Bahamas is common law, so we pretty much follow British common law, and so that forms the basis for our laws.
So this would have nothing to do with the World Court or anything like that. If there is a case with a foreign agency.
Well, there are general principles and guidelines, and we'll see how they line up when we begin talking about the Data Protection Act and how our Data Protection Act basically, we kind of in a lot of instances kind of like cut and pasted. Okay, and so you'll see that there were different jurisdictions. Some will be listed. Some will be listed in the presentation. Some won't.
Okay.
But as with we headed towards a global not just international but more global environment, and so we find that we have to either amend our laws or create new laws that will bring us into conformity with other jurisdictions where we don't fall in line. Okay.
Thank you.
So again, when we look at the Data Protection Act, we say, well, why do we have to have this act? If we already based on our common law. The common law and the case laws of the UK, but it has to be done in order to link it all together and to cover any loopholes. Okay. So, the bank must comply with a lawful court order to disclose, but must keep the court order confidential. In the Barclays Bank 1989 and Robertson 1994 cases, under common law principles, the courts will not allow fishing expeditions by third parties into the financial affairs of banking customers. And then in one of our own cases, the Bank of America Trust case, 1993, the court will not condone attempts by a foreign court to pressure a bank licensed in the Bahamas, but having its parent company in that foreign jurisdiction to violate the banking confidentiality laws of the Bahamas. With regard to the preservation of the duty of confidentiality, it is highly recommended that the terms and conditions of opening account forms by banks contain a carefully crafted waiver or indemnity clause that allows the financial institutions the express consent to allow confidential information to be vetted by a third party, even if that third party is the parent company of the financial institution. And again, we refer to the vis-a-vis the Turner case, the 4 qualifications, exceptions, which we must bear in mind. So there they are, under compulsion of law, in the public's interest, in the bank's interest, or with the express or implied consent of the customer. So it's felt that by doing that, we will preempt some of the difficulties that we've had in the past, or if you haven't done it yet, you will preempt any that may possibly arise by inserting this this clause. Okay. I know there was one financial institution several years before we had the credit bureau was even, well, we were talking about the credit bureau, but before we actually did anything to start putting it into effect, there was a financial institution that actually had to sign off on their loan applications that that they would allow the financial institution to check credit bureaus and any other financial financial institutions, places that may have credit, if people can get credit, in-store credit. So like I guess people have credits at service stations or like Kelly's, some of these, or furniture stores. It gave them the ability, the customer would sign, and it had that clause built in even in their loan application. So that was that for that in our institution, they were really forward thinking. Okay, the Banks and Trust Companies Regulations Act, Section 19 allows certain information to be released, approved by the Inspector of Banks. The BTCRA also allows the governor of the central bank to provide certain information. Okay, and then there's any breaches to the statutory duty of confidentiality. The penalties are a fine up to a maximum of $25,000 or 2 years imprisonment or both. Okay, so that's the penalty. All right. Let's jump right into the Data Protection, Privacy of Personal Information Act, 2003. For short, we call it the Data Protection Act. Okay, and we look at some areas why it was enacted, some definitions contained within the Act, some of the principles for collection, quality and use of personal information, some protections under the Act, and some exceptions within the Act. So first of all, let's look at why it was enacted. So the Data Protection, Privacy and Personal Information Act 2003 was enacted in June 2003. It was designed to protect the privacy of personal information on individuals, particularly consumers, locally and jurisdictionally. And it also established a Data Protection Commission as the operative agency to regulate the Act. Last earlier, my response that our acts and our laws pretty much mirror international guidelines, international laws, our common law jurisdiction as well, and those case laws. So so first of all, the Act is based upon the privacy guidelines established under the OECD guidelines for the protection of privacy and transborder flow of personal data. Also, the Council of Europe Convention of Individuals with regard to automatic processing of personal data. The Swiss Federal Law on Data Protection, and also a compendium of data protection legislation from several European and there are some that are well patterned after to some extent, but possibly influenced by, and there are about 3 of them here that I will list. The USA, they have their Cloud Act of 2018. China, the China Internet Security Law of 2017. And the EU, European Union, has the General Data Protection Regulation Act of 2018, commonly referred to as the GDPR. I read a very interesting article by, where this information is actually taken from, Data Protection and Privacy by Mr. Ryan Pinder. Back in October 2019, he spoke to a conference in Jamaica. The European Union's GDPR, according to him, has the most extensive provisions in it. And I'll make that, I'll either send a link or probably just send a PDF of Mr. Ryan Pinder's address for those of you who are interested in reading up on that. Okay, and this information is in blue here on the chart because it's not in your text. Okay, so let's look at some of the important definitions outlined in the Act before we get too much into the Act itself. Okay, so we can look at several, and here are the first 3. Data is information in a form in which it can be processed. Okay, so you know that can be written, recorded, you know, voice recorded, etc. Okay, so however that information, whatever form is in, and it can be processed. Personal data is information relating to a living individual who can be identified either from the data in conjunction with other information in the possession or control of a data controller. And we'll look at the data controller, the definition in a bit. But before we do that, I want to look at let's look at personal data, and let's dig a little deeper in that. This is not in your book. But sensitive personal data, and this relates to specific categories of data, which are defined as data relating to a person's racial origin, political opinions or religious or other beliefs, physical or mental health, sexual life, criminal convictions, or the alleged commission of an offense, and trade union membership. Okay, to a lesser extent that most of these, some of these or most of these may or not relate to us now, but they're increasing in importance. But certainly in America, the UK, the EU, and other places around the world, these sensitive personal data issues are certainly to the forefront. So now let's get to the data controller. Who is the data controller? The data controller is a person who either alone or with others determines the purpose for which and the manner in which any personal data is or are to be processed. The data processor is a person who processes personal data on behalf of a data controller, but does not include an employee of a data controller who processes such data in the course of his employment. Then we have the data subject, which will be the last one here. An individual who is the subject of the personal data. Okay, so the person who all this information is about, they're data subject. Okay, so if it was about me, I would be the data subject. One of the primary objectives of the Act is to ensure that information is obtained by fair and lawful means, and that it is used in a manner consistent with that for which it was collected. Also, persons collecting and using personal data on individuals are required to observe and abide by specific standards of confidentiality in respect to such data, and are prohibited from transferring personal data to jurisdictions with less stringent data protection legislation without the consent of the person from whom the data is obtained. The Act applies to both the public and private sectors and to the Crown, to the government. However, it does not apply to personal data which is obtained or used for matters relating to national security. Information that is required by law to be made available to the public by the data controller, and information obtained, secured, and used by family or household or for recreational purposes. The data controller has the obligation to abide by the requirements of the Act with respect to information of the data subject in order to protect the privacy of individuals and achieve the primary objectives of the legislation. Generally, there are 8 principles or rules that the data controller must follow, and they are as follows. 1, the data should be collected and used fairly and by lawful means. The data should be accurate and kept up to date. The data should be kept for specific purpose or specified purposes. 4th, the data should be adequate, relevant, and not excessive in relation to the purpose for which it is kept. 5, the data should not be disclosed in a manner that is inconsistent to the purpose for which it is kept. 6, the data should not be kept for longer than is necessary, except where the data is historical research or statistical data. 7, the data should be kept securely from unauthorized access, alteration, disclosure, destruction, or accidental loss. And the 8th one, which is not in your manual, the data does not be transferred to another country unless that country has an adequate level of protection. Okay. The Data Protection Act applies only to data controllers who are connected to the Bahamas in the following one of these 2 ways. The data controller is an ordinary resident or a company incorporated or registered in the Bahamas, or an individual who maintains an office, a branch, an agency, or practice in the Bahamas and processes the data in connection with business establishment. Or a data controller is not established in the Bahamas, but uses equipment in this jurisdiction for processing data that is not restricted to data in transit. What are some of the rights of individuals under the Data Protection Act? So we're going to look at several of these, and we're going to look at them in sections 10 to 12. So there's a right of rectification or erasure for personal data that is inaccurate, and I think that may be expounded a little, or these may be expounded, to some extent in your manual. Some more than others. The right to prohibit the processing of personal data for the purposes of direct marketing. Okay, so for example, let's say that, let me give an example. Let's say that I work for ABC Bank, and there's another bank, XYZ Bank, who is looking to divest itself of its loan portfolio. And so as part of the process, sometimes a financial institution will have one of their people go there. So from ABC Bank would send some to XYZ Bank. Look at the portfolio, look at the quality of the loans. For example, how well they're being serviced. Try to get an idea of how the clients are servicing the loans. Looking to see what the interest rates being charged are consistent with their own interest rates. That there's adequate collateral security, and et cetera, et cetera. So you're looking at the quality of the loan portfolio. And then you go back and you report to you report to ABC Bank. ABC Bank decides, no, we're not going to purchase your portfolio, your loan portfolio, or portions of your loan portfolio. But then they turn around and they use information and go to those customers direct. Okay, so so you're prohibited from doing stuff like that. Okay, under this act. The right to sue the data controller for any breach of statutory duty of care. That's section 12. Okay, so sections 10, 11, and 12. They give us the right of rectification, the right to prohibit the processing of personal data for the purposes of direct marketing, the right to sue the data controller for any breach of statutory duty of care. And then section 13 gives us the exceptions, the protection exceptions. Notwithstanding that the Act provides protection for the disclosure of personal data generally, under section 13, such protection may be overridden in the following 8 instances. And so we will go through those 8 instances. In the interest of national security as determined by the Commissioner of Police or the Commodore of the Defense Force, for the purposes of criminal investigations, prosecutions and the collection of taxes, duties, and similar levies, the protection of international relations of the country, to prevent injury, damage, or loss to persons or property, any disclosure required by enactment of or the enforcement of a court order, any disclosure required for the purpose of obtaining legal advice or required as part of legal proceedings, any disclosure made to the data subject concerned or to a person acting on his or her behalf, or 8, any disclosure made at the request or consent of the data subject or person acting on his or her behalf. Okay, so they have 8 protection exceptions. Section 14 deals with the Data Protection Commissioner. First of all, it provides for the appointment of the Data Protection Commissioner. And 2, it states that the commissioner, the powers of the commissioner, and they are as follows. There are 4 main ones: to issue information, enforcement, and prohibition notices, to appoint authorized officers for the purposes of inspection and examination, to restrict the transfer of personal data to jurisdictions that do not provide equivalent individual data protection, and 4thly, to prosecute offenses under the Act. Okay. Any questions on that before we move on from the Data Protection Act? Okay,
No question.
all right, let's okay. So important aspects of legal liability. There are various aspects of potential or actual legal liability to observe, and a number of these we've come across before. I think module 6 and maybe module 8, I'm not sure. Okay, but definitely some of these in module 6. So they are contributory negligence, exclusion clauses, Protection Act, which we just talked about, misrepresentation and mistake, undue influence, tortious liability, negligent misstatement, breach of trust, and restitution. Okay, so these are some other aspects of potential or actual legal liability which must be observed in contractual relationships between financial institutions and their clients. A key component of this is, and we touched on this earlier when we talked about the service the service agreements and the opening accounts forms, and but here we're now going to expand it to generally to not just the clients but also service providers. So client and service provider agreements, so standard terms and conditions. And the recommendation is that in drafting and reviewing various client and service provider agreements, financial institutions must consider the following terms and conditions. And there are a number of them, I think about 22 of them outlined on that page, starting with parties, scope and nature, duties, obligations, rights, responsibilities, prohibitions, and restrictions. And it goes all the way down to regulatory and legal compliance, and ending with risks inherent in a contractual relationship, including but not limited to, and there are these 6 risks: compliance risk, legal risk, liability risk, operational risk, regulatory risk, and reputation risk. And we're going to look at some definitions of them, and very briefly. So first of all, compliance risk. Compliance risk is defined as the risk of legal, material, financial loss, or loss of reputation the bank may suffer as a result of its failure to comply with laws, its own regulations, code of conduct, and standards of best or good practice. Legal risk is risk arising from failure to comply with statutory or regulatory obligations. Liability risk is a risk to a company arising from the possibility of liability for damages resulting from the purchase, ownership, or use of a good or service offered by that company. Liability risk can be identified and mitigated through careful product design and testing, but may also be inherent in the nature of the product to some extent, as in the case of automobiles or pharmaceutical supplies. Operational risk. Operational risk is the prospect of loss resulting from inadequate or failed procedures, systems or policies, employee errors, systems failures, fraud or other criminal activity, or it is any event that disrupts a business's processes. Okay, and then the final 2, regulatory risk is generally defined as the risk of having the license to operate withdrawn by a regulator, or having conditions applied retrospectively or prospectively that adversely impact the economic value of an enterprise. enterprise that adversely impact the economic value of an enterprise. Reputation risk, which is also often referred to as reputation risk, is a risk of loss resulting from damages to a firm's reputation in lost revenue, increased operating capital or regulatory costs, or destruction of shareholder value consequent to an adverse or potentially criminal event, even if the company is not found guilty. So a lot of times the damage has been done, as we saw in the Enron case and Citibank, and Arthur Anderson, who was the accounting firm, and in fact they actually went out of business. So some important aspects of legal liability. Well, there's some effective action steps that can be taken in managing legal and other risks in contractual relationships. And these action steps that a financial institution should follow to ensure the legal viability, effectiveness, and risk management of its contractual relationships and agreement, which underscore such relationships, are as follows. And again, they're on top of that, the page in your manual, specifically discuss and document client and service provider expectations, performance standards, and scope and ambit of duties, obligations, responsibilities, and rights. Review all existing client and other agreements for legal, regulatory, and financial compliance. Conduct internal audit of all legal and contractual documentation. Review and address clients' complaints, particularly those based on contractual duties and performance standards. Assess and understand the specific contractual provisions and their relevance, effect, and impact internally and externally. Fifth, conduct ongoing staff training on contractual documentation and implementation. Educate clients and all relevant stakeholders on the important provisions on the contract agreement and the nature and scope of the contractual relationship. Also protect and preserve client information and the financial institution's confidential information, trade secrets, policies, and procedures. And then finally, ask the appropriate person, advisor, senior manager, or director if you don't know. The financial institution or client relationship should neither be taken lightly nor treated carelessly in light of what is happening worldwide, where we have a legal and global environment that has become more and more litigious, where the demands and dictates of laws, regulations, international and local best practices require nothing less than professional responsibility, integrity, transparency, and accountability. So there's that drive, not just locally but internationally, and even here in the Bahamas, we find that our people are either as plaintiffs or are being drawn into legal battles in the Supreme Court in order to get matters addressed and resolved. Secondly, the financial institution or client contract has both express and implied duties and rights for the financial institution and the client. The illegal issues that arise often relate to some breach of those duties and or recognition of the rights of each party. The legal defenses and remedies available to the parties are dependent upon the actions of the parties in operating the account or in complying with the bank mandate and in mitigating risk and or loss in banking transaction involving these parties, that is, the bank and the client, or the financial institution and the client. And fourthly, whether in the role of plaintiff or defendant, some of the important considerations that must be taken by both parties in commencing or defending a civil action for breach of contract, negligence, tort of conversion, or some other civil wrong, are the cost of the action, the time involved in adjudicating the matter, the publicity, the convenience or the inconvenience, and the need for a ruling. Okay. Those outlined in your text. Banks are often advised to take a practical approach or reasonable man's approach to resolving legal issues before proceeding to commence an action or initiate legal proceedings. All facts should be investigated, reviewed, and analyzed in order to determine the strengths and weaknesses of each party's legal and or commercial position in the context of the duties and rights of the parties based upon the banker-customer contract. Okay. So those are the effective actions, steps, and some practical advice on resolving. Any questions on that before we take a quick dive at credit risk? Okay, well, let's look at credit risk and some definitions. Okay, so the first one is the OECD definition, since that is one of the most, one of the main driving forces, in the past and currently. So the OECD's definition of credit risk is a risk that one party to a financial contract will fail to discharge an obligation and thus cause the other party to incur financial loss. Then we move to the definition by our own Central Bank of the Bahamas. Credit risk is the risk of financial loss despite realization of collateral security or property, resulting from failure of a debtor to honor its obligations to the licensee, and the licensee being the financial institution or the lender. Okay, and then thirdly, one taken from Wikipedia, a credit risk is a risk of default on a debt that may arise from a borrower's failing to make required payments. Okay, so there you have three definitions of credit risk. Okay. So how do you manage credit risk? Well, there are some guidelines, again, put out by Basel, the Basel Committee on the Basel Committee. They have some guidelines, and there's 3 points in which their effective risk management guidelines. And the first is establish an effective credit risk environment. Okay, so establish an effective credit risk environment. The second is to operate a sound credit granting process. Operate a sound credit granting process. And then thirdly, appropriate credit administration, measurement and monitoring process. Okay, so the first one, there's some considerations that need to take in place. Establish an effective credit risk environment. And so well, that begins with the executive management, but actually the board really coming down, establishing um, their products, because they're going to be establishing, what products they want to sell to the public, the interest rates that they got, what collateral security, if any, what percentage, contribution is required by um, the client, and all of these things are embodied basically in a policy manual or credit manual. And in addition to that, you also want to be able to your risk. So you'd want to introduce some sort of risk rating regime. So you rate anything from moderate risk all the way up to high risk, so that and that's on your client. So again, you look at your client, you look at the client, the population. So you look at some demographics. You look at where the highest risk are. Is there a certain category in the economy that are higher risk than others? Are there, age brackets? Are some higher risk than others? Some loans are more high risk than others. So, for example, you may say, "Well, we're not going to do startup business loans because they're too high risk. We'll probably, unless they're secured by some solid collateral that we have an exit way out." So the first thing you want to do is establish an effective credit risk environment, and again, that comes from the top down, and so mainly, you have your products and you have your lending manual, and that outlines the products and the risk factors, including a risk rating regime. Okay, you want to operate a sound credit granting process. So you want to have it properly structured, and we looked at that to some extent in I think that was module. What is that module? 7, I think it was. Okay, you looked at the credit granting process for mortgages, but it pretty much follows for all credits. It pretty much follows a similar pattern. Okay, you have people who generate the credit. You have people who review the credit, make the decision. Then you have the persons who actually will book the credit. Okay, and you have a group of people who, if something goes wrong, delinquency, you have a group that will try to rehabilitate that credit. And if they're not able to rehabilitate that credit, get it back on a good foot, then they will look at recovering or liquidating, recovering the bank's money by liquidating any collateral security or pursuing the client for any monies that he or she may have, or any other assets that they may have that can liquidate or assist in liquidating the debt. And then, of course, the third one is to maintain an appropriate credit administration, measurement, and monitoring process. That's an ongoing. That's an ongoing activity, and is an activity that should be reviewed periodically. And again, we touched a little bit on that when we looked at the 4 pillars. We looked at the branches. We looked at origination, where the loan originates. We looked at credit underwriting, where the loan is adjudicated. We looked at credit administration, where the loan is booked, and they follow up in terms of compliance for the loan documentation. And then the 4th was the collection center, or recovery center. So you want to make sure that there's a process in line for the credit. And if it ends up in the hands of your loan servicing or recovery department, if they could rehabilitate it and shove it back to the originators, the branches can then, over a period of time, possibly farm out additional credits from it. And then continues. It goes to adjudicators. Adjudicators hopefully approves it. It goes to the credit administration, or to the lawyers first, if legal process is involved. Then it's drawn down, and then again it is monitored by the branch to make sure that it is functioning properly, and also the branch also monitors it. So, for example, if the client has paid off 75% or more of their loan balance, you may want to look at how can I get them on the hook for a new loan or any facilities, and so then the process continues to revolve. And of course, monitoring is done by all four of those pillars. That is the branch, the credit underwriting, or the adjudicators, that is, the administration team who inputs and follows up for collateral security, and also the loan servicing, that is the collection department. So everybody is involved in the monitoring process for the other. And of course, you also have a lot of this collective data put in reports and summarized in one form or the other, that goes to executive management and filters all the way up to the board of directors. And the board of directors reviews this summary information, and they make determinations based on that. Okay, so in a nutshell, that is the Basel Committee guidelines establishing an effective credit risk management environment, operating a sound credit granting process, and maintaining an appropriate credit administration, measurement, and monitoring process. Now, there's some risks inherent, and there's a list, but that is not, it's a partial list. It's not exhaustive, but it covers some of the main risks. And some of them we've come across before, like credit risk, compliance risk, operational risk, regulatory risk. And then these ones they're added, financial risk and liquidity risk. And so we look at those the definitions of those two in the next slide or two. Okay, so we have financial risk is an umbrella term for multiple types of risks associated with financing, including financial transactions that include company loans and risk of default. Risk is a term often used to imply downside risk, meaning the uncertainty of a return and the potential financial loss. Liquidity risk is a risk that a company or bank may be unable to meet short-term financial demands. This usually occurs due to the inability to convert a security or hard asset to cash without a loss of capital and or income in the process. Okay, so shell that's credit risk. I don't know if you have any questions on credit risk or any of the other information. At the end of the chapter, there's some definitions, some other definitions. So you could read up on those. Are there any questions? No questions?
None of this No questions.
The question I would have had was the credit bureau, and you already explained that early next year. It's still on the agenda.
Yes.
All right.
Yeah. They're collecting information. The extent, and this is my personal view. So the extent to which you may have a different opinion, that's fine. But my view, even when the credit bureau has collected all of the relevant data in order to input information regarding clients' credit worthiness, it is my belief that the banks will, or lenders, let me just say, lenders who use will not strictly adhere to that or use that as the ultimate what would I want to use?
Deciding factor.
Yeah, as an ultimate deciding factor. Like they will not use that as the goalposts of all goalposts, as a financial Bible, so to speak of. It won't be like the commandments.
Do you think
Okay.
that, do you think that if there's a person who has a judgment against them, that would not be shown in the credit bureau's agency, right?
It's supposed to be. It is supposed to be part of it.
Okay.
It's supposed to be part of it. And so for example, when we were talking about the Homeowners Protection Act, okay, and we were talking about that the judgment expires after 6 years of the court order, or after the date of the last payment, right? So if that judgment is not satisfied fully, and it goes by way of, it happens that your client was able to, you were able, the client was able to go through that 6-year process. That would be reflected that the judgment has not been settled, and it will reflect that the client, him or herself, did not settle it, but it just they just were not required by law because of basically default. But I should say default, by being statute barred. Okay. Now there may be some people who will still show judgments outstanding against them that have been settled, but they have not been marked settled because financial institutions have not been as diligent as they should be in having the mark settled, or issuing what you call it, having the mark settled. Okay. I know of a few cases where lawyers have had to follow up, where matters were settled. One way or the other, either fully paid off, or they reached some agreement, but the bank had not made that last step to go to the registry and mark it settled. So it still showed up when a client came to us to borrow again. It showed up that there was a judgment outstanding against them. So there's going to be some cleaning up that financial institutions, lenders will have to do in order for that not to happen to clients. Or if it happens, the client can challenge it, as with credit bureaus around the world, especially in America. And they will have to rectify the records. But going back to the lending side, because we have so many people in our country who are over leveraged financially, okay, there are very few people who you can find that have debt service ratios of 50% or less. Okay. And the central bank recognized that while they had set the debt service ratio ceiling at 45, they realized that in order for a lot of financial institutions several years ago to survive, they needed to accept that they could go up to 50%. Okay. But you have a number of people who are much higher than that. Okay. And the majority of our people are higher than that, even those who are showing 50%. Okay. And the reason for that is that some of the information they are not declaring when they go into to get a loan, because the clients are now smarter. They know that if I leave out credit cards, if I only tell them about one, my debt service ratio will be lower. Okay? So they only tell you about one credit card. And then on the other hand, you have, unfortunately, some unscrupulous lenders who, because of quotas, the pressure on quotas, and we talked a bit about that when we were talking about ethics.
Yes, sir.
Right? Who will now exclude that to say that I want to get this loan approved, so I will leave out certain information. So if you have 3 personal loans at 3 different banks, I can only put 1 or 2 of them. I can leave with the other second or third one. Or I will leave out credit cards. Or instead of saying that you say you live with your mother or live with relative. Okay? So there are a lot of instances. I was a credit adjudicator, and I've seen a lot of them come across my desk, where lives with parents, lives with relatives. Some of the financial information, it just doesn't add up. When you look at the statement of affairs, and a person making a certain amount of money over a certain period of time, and that person was just wasting their money, or they're lying. They're not declaring all of their assets, or they're not declaring all their liabilities. And so it's important that we have these tools available to us in lending.
Yes.
The client gives us demographic information. Okay, where they live, the age, how long they've been working, the income, dependents, etc. Then we get their statement of affairs, the list of assets, the list of liabilities. Okay. Then we get their salary or their income information, but we do not connect the dots. Okay. We don't connect the dots. Looking at this, there was a case, and let me see if I can quickly find it and actually bring it up. Okay. I think I have it here. This is something that actually happened. Okay. This is a case scenario. A 25-year-old comes into your bank to borrow $50,000 to complete a townhouse gated community consisting of 10 single standalone units, which would be worth of $500,000 for completion. Okay, so 25-year-old wants to borrow $50,000 to complete 10 single standalone units in a townhouse gated community. Okay, which would be worth in excess of $500,000 upon completion. Some of the details related to his application are as follows. He's been working since he was 17 at an appliance business he started. He currently pays himself $60,000 per annum. This is at the time of the application. The assets include a modest price automobile, not more than 3 years old, along with $15,000 in cash and several real estate assets totaling just over $2 million. Okay, so 25-year-old, been working since he was 17, paying himself $60,000 from an appliance business. Okay, there are no debts attached to any of the real estate assets, and he has no other significant liabilities, so much so that his net worth is around $2 million. Okay, so he has real estate assets totaling just over $2 million, so his net worth is around $2 million. The townhouse complex is in an area known to be the stomping ground for a major drug dealer, convicted and serving prison time. He provides a copy of the conveyance to the land, which shows a consideration of $20,000 for property that is easily worth $125,000. Get this, the vendor on the conveyance is the convicted drug dealer. The conveyance was completed before his trial and conviction. And the question that I was going to ask in the ethics class had we gone through this one, how should you handle this mortgage application? Okay, but here's a case where, you know, even if so at age 17 he started working. He's not always getting $60,000 a year, but let's assume from 17 he was getting $60,000 a year, earning $60,000 a year. Okay, between the age of 17 and 25, that's 8 years. Okay, 8 times 60,000 doesn't give you anywhere even $1 million. So how is it he has assets of we you know, and they were impressed by he did this and that or whatever. But then what was the implication? And plus you had the conveyance where the name of the drug dealer for the property that he was on. And so my question to him was, if that loan goes bad, who going down there to collect? Okay, but see, this was an attempt by this individual to legitimize a transaction. So if someone came, you know, and inquired or whatever it is, then he say, "I'm not paying a mortgage on that, boy. I got to pay them. I got to go to the bank to pay my mortgage." Okay, but $50,000 he could pay that off in less than a month. But his intention was to legitimize you know, what had transpired. There was just too many things wrong. So we are given information, but we either one, don't connect the dots, or two, we deliberately pay a blind eye to the information that's being fed to us. Okay?
I would have been.
And so I go back to my.
Is this case fictitious, or is this real? This
is a real case.
Wow.
That then came across my desk. I'm telling you that the loan officer wanted there was a senior loan officer who wanted to process that mortgage application. And we ended up completing a report on this to the Tingham unit, financial Tingham unit, FIU. I referred it to the compliance manager. You know, but getting back to my initial statement about the credit bureau and the information, we're gonna have information given to us. But if we really pay attention to that, to the data and the information that's provided to us on those clients, there's going to be very few people in this country who actually qualify to borrow. Very few. Okay, there basically probably three. There are three categories of people who of legal age who don't have loans now. Okay, that's the ones like on the police forces, defense forces, and immigration, who us as bankers, we haven't swarmed on them yet because they're still in training, but we wait until they have their falling out parade, and then we swarm on them and try to give them loans and tie them down. Then they're the super wealthy who need to borrow, and then there are them people who are too old to borrow. And that's probably like 5–10% of our of our population, 5 to 10%. That's my guesstimation. The rest of us, the other 85–90%, or 90–95% of us, we are over leveraged financially. You know, whether that's over 45% or up to 95%. I had an instance where there were two. One was a female, and both were deputy directors in government. And the male deputy director, he didn't have even enough money to get his suits cleaned. After the salary reductions, he didn't even have enough money to get his suits cleaned from the cleaners. To profile as a deputy director. Right? The female, her car broke down. We told her, man, you're a deputy director, tell the government they need to give you a car. Okay, these are people who were left with like with $14 and so dollars out of their salaries. And they were making good money as deputy directors. And they both went on to become directors. You know, so we had a you know, I guess in a way this pandemic has caused us to stop and take stock of our finances and where we're headed individually and collectively as a country. You know, and a lot of it, we as financial institutions, we are to blame a lot for it. Our educational system is also to blame for it because we don't teach money management in school. Our parents are also to blame. Very few of them taught us money management skills at home. So we have the parents falling down, the educational system, government and private, failing us, and we have the financial institutions failing us. And of course, we're failing ourselves by not taking the initiative to learn and to better ourselves and look at other people and see where they, because we are driven by what we see in America, which is a consumption-driven economy. You know, heavily reliant on debt rather than on cash.
Mr. Nordic, you know, for most of us Bahamians, we are still afraid of investment. Even I'm still afraid of it.
Again, that's because of how we are as a people, you know. That's our nurture. Okay, sure. We are by nature, we are risk takers. That's why we break laws. No matter how small the law is. We may tell a lie, thief a pencil from WIC. We may run the red light. Okay. By nature, we are inquiring people, but by nurture, again, going back to our parents, our schooling, our civic and church organizations, they failed us big time in terms of creating that thirst in us to, you know, unlike the Greek, the Jews, and the Chinese, you know, but mainly the Jews and the Jews and the Greeks. The Jews and the Greeks, they teach their children to to be entrepreneurs. We teach our children to be employees, get a good job. And until and unless we are forced. And so like in this situation now, there's so many small businesses that started as a result of this pandemic. And so in a way, that has been good for us. You know, my mind goes back to pre-1967. Okay, when the UBP was in power, and the four black people and women had the right to vote. Okay, only people, well, only the white people, quote unquote, white people in the Bahamas, who had property, were entitled to vote. Okay, and so the Bahamian people, the black people, made noise. They said, "We want the right to vote." And so then the UBP government said, "Okay, you want the right to vote? Okay, one, you got to be 25 or older, and you got to own property." Well, that excluded just about everybody. Okay, because who back in that time owned property? Black people. Okay, so our grandfathers, and some of us who old as fathers or great grandfathers, and of course you had to be male. Okay? So they excluded the women. Okay, the women came later, you know, with Georgina Simonet and some of those who fought for the right of women to vote. So this is before even women had the right to vote. Black men didn't even have the right to vote. And then when they gave us the right, 25 and own property. Okay? So what a lot of them went out and did, a lot of them went out and they started buying property. That adversity forced us to become property owners. And guess what? If you look at all of the wealthy people, most wealthy people in the world, with few exceptions, okay, like Bill Gates and whatnot, okay, the majority of the most wealthy people in the world made their wealth through real estate, okay, real estate development, or using real estate for businesses, or flipping real estate, okay, just churning it over and over and over and over and over, okay. And that is why we began to have a class of black people in our country who became wealthy. The Sunshine Boys, they pooled their resources together. Initially, they had the Penny Savings Bank, and then they branched out into some other stuff. Some of them, you know, formed the Sunshine Group, which now is primarily now Frankie Wilson. So Frankie Wilson and a few others. But the basis was real estate. The basis was real estate. They began to understand that concept. That unless you or Bill Gates are coming up with Microsoft or whatever it is, the majority of the most wealthy people in the world started, their roots were in real estate. And had the white UBP people understood what they were starting, they didn't realize that they had at least a few black men who would take up that challenge, because their attitude towards blacks was, man, they too laid back and lazy. But then there were a few who started and got the ball rolling, and others followed. And that's what I see happening again with all of us, white, black, brown, in between Bahamians, in this pandemic, finding ways to start a business, to be entrepreneurs. Like the Prime Minister said, some people starting the business, making making the masks. Okay, some people expanding the business to do sanitizers, like the liquor people using the basis of their products to do hand sanitizers. And then all of this kind of things started blossoming. Then unfortunately, some stuff happened. Some of the restrictions, you have some people being discouraged, like the fellas selling coconuts on the side of the road, coconut water, coconut, some of those kind of things. And that for the most part has pretty much been addressed. Okay. But those are my thoughts. But as financial professionals, you all are doing the right thing in terms of educating yourselves. And I would even say to look at other to look at some of the other courses that even BIFs offer that take you on a track, particularly those that will give you a skill. Some of you may want to get into compliance. There's some accounting courses you may wish to probably go into accounting, and because forensic accounting is popular now. Or you may look elsewhere other than the institute for some management classes that we may not offer right now. But develop those skill sets. Give yourself a skill. Become an expert. Some of you out of this course, you may decide, hey, but this has met my appetite to pursue law. Okay, you want to get into specific aspects of law, international law, wealth management, and that type of thing. So the field is wide open, and I'm assuming that most of you, if not all of you, are still young, and even if you aren't, you're still breathing. So there's opportunities out there. We just have to grab them. I recently became a senior citizen, and I'm still looking for opportunities. So. That ends our class. All the best in your exam and your studies.
Thank you. That was very well said. I'm glad you encouraged us tonight. And hopefully it didn't fall on deaf ears tonight. So thank you.
I'm sure it is. Again, I will send the PowerPoint presentation and also that PDF of Mr. Ryan's speech on the Data Protection Act, because there's some aspects of it that he actually gets into in detail. Those 8 points, he really gets into some detail, and then he also gives an overview on the international. So he begins by talking about the national side, and then he talks about our Protection Act specifically. So to me it was a very eye-opening and enlightening article. So I'll the extent to which you may be interested, it's up to you.
Mr. Nord,
I will.
Mr. Nord, knowledge is power, and I like the aspect of the cases, so we can have some real-world experiences to apply it to your teaching, and it's very good. Thank you, sir.
You're quite welcome. And again, all the best to you. Again, my section of the exam there'll be 2 sections from me, true and false and multiple choice, 25 questions each for my 50% of the exam. And Ms. Archer, I understand she has completed her questions and submitted them to the Institute for a portion of the exam. So you'll be guided by her on that section, and likewise by me on my section. And hopefully, if you review the well, like I said, I sent questions on the 6 modules. They'll pretty much guide you as to where to focus on the because they're taken from a pool of several hundred questions, and you know, sometimes some of the questions repeat themselves because what is not in may come up again in some form or fashion under multiple choice and vice versa. So because there's only so much information you could get questions from, eh? So, all the best in your studies. I look forward to a high percentage of you passing, if not all of you passing. Good night.
Thank you. Good night.
Thank you. Good night. Good night.
Good night.
Good night.